And we are live. Alicia, I'm not sure if your volume's on. No, I cannot hear you. Nope.
How about now?
Yay! There we go.
Yippity skippity.
All right. Good afternoon. How are you?
I am all right. I am here. I could not find the shirt I wanted, but we make do. We make them.
Your shirt is lovely.
How are you?
I am fine. Coming in hot a little bit because I needed to grab some lunch, and that took a second. Hey, Lisa. That took a second, but I think I barrel rolled under the under the door just
Safe.
Yeah, just in time. For those of you who may be newly joining us, I am Jill Bates-Moore. I am one half of the lawyer team at Dahlia Law Group. I greet you today with the joy of my Afro poof. We're just letting the poof reign today. Dahlia Law Group is a Black woman-owned law firm in Oakland, California, where we do the work of legacy. And so we practice in legacy and estate planning, probate, which is what we'll be talking about today, and litigation that is mostly related to those areas. Who are you, my friend?
I am Alicia Holland, the other half of the lawyer team at Dahlia Law Group, and she is the squeaky chair.
Naomi is here. Hey, Naomi. Danielle is here. Hey, Danielle. And Lisa is here. How you doing, Lisa? Today we are gonna be talking a bit about probate. And as we sort of set up that conversation, we are very interested to hear how you all are doing. We're really asking. There's a lot in the world. It is Wednesday, October 21st. We are 2 weeks out from a nationwide election that's going to affect us at the national level, but also we have plenty of state and local things on those ballots that you're wrestling with right now. So we all stand to be affected together by the decisions that we make. There's that. There is global pandemic. There is that. There are wildfires in California, in Colorado, in Utah. Washington or Oregon was burning at some point. There's so much. The state-sanctioned police forces in Nigeria have turned their guns on peaceful protesters. Hashtag end SARS. If you don't know what that is, look it up. Activate, amplify, because all Black lives everywhere matter. And so there is a lot happening. There's a lot happening, and not all of it is bad, right? So there's also stuff that we get to do. I am presently broadcasting from my my room that serves as office, as sewing room, as crafting room. I get to do all of those things. So and be in touch with some creative outlets, which is not a bad thing at all. So let us know how you're doing. And as you think about that, we are going to set up the probate conversation today. Alicia, what are we talking about, and how are we going to talk about it?
We are talking about probate today. What is it? Is it all bad? Why is it? What does it mean? And so in the existential what is probate conversation, what we're going to talk about are some of the kind of breaking down the steps of probate, not minute, but high level, kind of the big category steps, and some practical tips for each of those to have you set up that if you are in that state, uh, how you, to know some tips of how to get through it most efficiently and effectively.
Yeah, so one of the things that those of you who have been here with us before, you probably know already, is that we really try to focus on some practical tips. And this conversation about probate is no different. There are plenty of self help sections of court websites all over the land that will walk you through the specific steps for how to get a probate action completed in your local jurisdiction. We practice in California, as I said earlier, so our advice, when we're offering advice, is California specific, but the practical tips are pretty universal, right? So our focus today, like Alicia said, is not just on, what are the steps, but how to approach that thing so that you can come out of a probate action with your sanity and your relationships intact, right? Because this is the sort of stuff that can really tax and test people. So let's get into it, shall we?
We shall.
Oh, before we do, oh goodness, Naomi, thank
We
you so
shall
much.
not.
So, Naomi said that she is feeling excited, exhausted, and yet holding on. And I just wanted to raise my salute and my mug to that because, yes,
That part
that
there.
part, very significant part. So, thank you for sharing that with us. Alicia, I'm sorry I interrupted you. Go ahead.
No, that was a worthy interruption. It makes me think of preacher Bishop Carlton Pearson, and in one of his songs, he has a old wise woman, church mother type that he always checked on, and he would always check in with her and say, "Well, mother, how you doing?" And she'd say, "I'm yet holding on, baby. You still yet holding on?" So Naomi saying that is like, yes, we are yet holding on. Stay yet holding on.
Indeed. So, Danielle says she's been fine, and I am glad to hear that. Lisa is sending hugs, which I am very desirous of. Like I've hit the point in this COVID season where I'm just like, and the weather is changing too, so it's starting to get cooler and that sort of stuff. Where I'm just like, ooh, give me all the hugs. So and so not being able to have that because sanitary distancing.
It's COVID.
Yeah. So yes, I will take all of those virtual hugs. Thank you, thank you, thank you.
Yes. In my mind dream the other day, I was like, well, I've seen where people have done those things where they do like the plastic wrap in the door with the arms for the hugs. And have you not seen these?
Mm-hmm.
And well, what I thought of was, can I use a Snuggie? Like if I Snuggie, can I hug and then just peel myself back out of it? I
Mm.
told you it was in my mind dream. Like I'm not going to actually attempt this because I know that that's probably not going to work out in the execution.
Mm.
So don't judge me.
I have nothing to say about this. Nothing at all.
Fine. Anyway, about the probate. So what probate is it is a court process that we use when settling estate for a person, which what that actually means is the court getting involved to make a final determination about who is going to get what and what bills are going to get paid, and then overseeing the process to make sure that happens. That's like super duper high level of what probate is. So then when we get into how do we actually settle a person's estate, you can really break it into three main stages of what is going to happen. That first stage has to do with opening the probate, which is really letting the court know somebody has departed us and we need to settle their estate, and getting an appointment for who is going to be the point person in making that happen. That's kind of stage one. Then second stage is, now that we have a point person needs to figure out what is this estate. And so that can be called an inventory and appraisal process. Another term that we might use is an accounting, and that really is where we are going to literally gather all this stuff and put it on the table and figure out what it is we're dealing with between the bills, the assets, how much they're worth, all of that. Then the last step of the process is, now we know what it all is, then we need to decide, how do we get, like, where does it go in the settling of it all? So now that we've got all the bills on the table, let's figure out what gets paid, prioritize those. And now that we have all of the stuff on the table after the bills are paid, who gets what, and making sure that it goes to them. And that whole step is final distribution. So those are kind of our three main stages that we're working with here.
Yeah, and that point person is called a personal representative. That person might be called an executor in some places under certain circumstances. They may also be called an administrator in some places or under some circumstances. But the role is the personal representative role, and it is a fiduciary role. So this person is not just doing a favor to the estate. This is not just somebody who's going to show up and, I'll take a stab at it. No, a fiduciary actually has a significant amount of duty. And we talk a bit more about that, a bit more specifically in a previous episode when we were talking about wills as sort of a primary estate planning tool. So go back to that episode. I don't remember the episode number, but it is not the last episode, because this most recent episode we talked about voting, but it's the one before that.
Yes. So thinking about, now that we've broken down our three stages, let's talk about kind of the practical implications of what do we need to do in each of those stages. So that first one, opening the probate. So one of the big things that's going to be a practical do it first, find the papers. Are there papers? Is there a will? Is there a trust? That can help, because that may give a blueprint for some of those next questions that are coming. It can also give a blueprint for identifying some of these assets and debts that are going to be coming here. And if we find papers, that might even limit how much of these next steps in probate we might need to do. So for instance, if we find out there is a trust, but there are some assets that are outside of it for some reason, then we might focus the initial energy, our initial probate energy, in trying to get as many of those assets transferred into the trust as possible, because what that's going to do is limit the court involvement and the court timing in this whole probate process. Another reason that we're going to look for the papers is because often when we have papers like a will or a trust, it's going to name who that person whose document it is wanted to be that point person. So is there someone that's named as an executor, and is that person willing and able to serve? Because if they're in the paper and they say, yes, I am willing to do that job, then that means we don't have to do a whole long HR process of figuring out who's going to be the person. We've already got our number one candidate, and we can get on with this process.
Right. So before oh, sorry. Can I interject here?
Yeah.
Thank you. This part is really key to do before you file any papers anywhere. And part of the reason for that is because, as you'll see in some of the further conversation that we have, it's the more that you know as the person who is essentially attempting to open the probate. And I know we didn't say this already, but I think that you can kind of see this conversation that way, right? Like, we are talking to the person or people who would be looking to open the probate. And I'm saying that because it is a little bit different from the way that we structured our previous conversations, right? Before, we were talking about trust, we were talking about wills, we were talking about setting up the estate plan and sort of getting prepared and getting ready. And here you can see we are kind of turning the focus of the conversation a little bit and actually talking about, all right, now we actually have to carry the stuff out. Something has happened. So either we had a plan or we didn't have a plan. Either there was a plan or there wasn't a plan, but somebody has died now, and we have to and we have to do some things. So this conversation is really to that person. And so part of this work is the getting ready. And I'm going to tell you, in a really, really basic way, the more organization you can have as either the personal representative or somebody who is, or somebody who is helping, right? The more organization you can have early on, the easier. And I know I'm using the word easy in the context of death and final affairs. But I mean that word. The easier it is going to be to carry out this process from a relationship standpoint, as well as from the court and administrative standpoint. In our work, one of the things that we find most significantly and most frequently is that when people are funking and there's just like the relationship has just gone downhill in the wake of somebody's death, it is frequently because nobody knows what is being done. And part of the reason that people might not know what is being done is because some folks aren't really clear on what to do. And so you get responses like, well, I got it, right? Or I'm handling it, or such and such put me in charge, or whatever, but not really transparent sort of action-based responses. And those things can really, really help. So before you even go to file any court papers anywhere, focus on this step. Focus on this step right here, and let's do this before you even print those papers off the internet.
Yes. And that also helps you with if there are potential issues that are going to come up, you can address those in those initial set of papers when you fill them out, which can be really useful for two reasons. Number one is because the people that are likely beefing are likely going to be people that are entitled to notice of this petition. And so you can speak to those, and it's really using this paper that is directed at the court to speak to some of those other people and those issues. But that also means that you get to put that issue in front of the court as well, so that if this person pops up, that it doesn't raise a caution flag in the courthouse when all of a sudden this new thing pops up and the court is like, well, wait, like this seems like there's a lot of drama here. Do I need to pay more attention to whatever these little kind of whack-a-moles that are popping out of the bag? Is if you put it all on the paper, then it's not a surprise, and it kind of takes the wind out of the sails if it's one of those people, because we all got some of those people that just try to insert foolishness for the sake of getting attention in their direction. It takes some of the wind out of their sails if it's like, we put all the foolishness on the paper, right, that we are talking to it and addressing it right here, right now, so we can move on and get to the important business here.
Right. And I think a fair bottom line takeaway from what we're saying here is that in instances where there has to be a probate or even a trust administration, this work has to be done transparently and in the light of day. A probate is done publicly because it's in a courthouse, whereas trust administration is not. Go back to that last episode I was talking about if that doesn't make sense to you, and reference that. But whether it's a public proceeding or it's done privately, it still has to be done transparently. This is my office movement, my motion for cards on the table, face up. That's the only way that we know how to do anything. And remember what I said about the personal representative being a fiduciary. The buck stops with that person. So cards on the table face up is also for your protection as the fiduciary, so that when this is all done, you can have confidence in the result, and there's no, sort of monsters or boogeymen under the bed that are going to come crawling out to bite you on the butt and potentially cause you some problems about what you did here. And then also, as a really practical matter, when we're talking about probate and there's a will, right? When Alicia said go look for the papers, if there's a will, first thing you got to do is have the will validated anyway. So you need to have the papers, or to know that there are not papers, to say, I believe that there was a will, or there is a will, but we only have a copy. I don't know where the original is, or whatever, right? Or there are heirs or people who need to be involved in the process who don't want to be involved in the process. And so, like Alicia said, getting all of that stuff, all of those cards on the table, face up, so that you know what you're dealing with. Also, the court knows what you're dealing with. And judges are people. If you show up with integrity and transparency, then you're going to get treated like that in most instances, right? Like, judges are people, so some judges are jerks. Yeah, I said it. But for the most part, the way that you show up is kind of how you're going to be treated in the process as well.
Yeah, it is true. One of our mentors in our trial life used to always say preparation is currency.
Yep.
And that is 100% true here, because the more you can be prepared, it's just going to help you, not just in front of the judge, but all the way through this process.
Yeah.
So with that in mind, one of your steps of preparation is, if there is no paper, so there is no will, and we're trying to decide who's going to be the point person, an important thing to know is that person going to be bondable? So if there is not a paper that says who the person is and that bond is waived for them, then the court is likely to require that person to get a bond. Now, what a bond is it is an insurance policy that is purchased by the estate to make sure that if the person is that's the point person gets it wrong, or has nefarious intent, or is an evildoer, then that there is some backup insurance there to help protect the estate and the value of the estate from the scoundrel.
Or the person who makes a mistake. Yeah.
Yes, it could be an honest mistake. They might not have come in it with their little pitchfork and evil ears.
It's coming up on Halloween season. Yeah, so Alicia's focusing on goblins.
Know how I can do it.
Exactly. But I do think that's actually an important thing to remind you of at this point is because that role is a fiduciary role, it is possible to have financial consequences from making a mistake. That's part of what comes with the fiduciary duty. So you don't have to be a goblin intent on stealing, but frequently, that's where people get pinged. It's because stealing's bad. Okay.
Put that in your takeaways.
Right. Stealing's bad. Okay.
Yeah,
so
write that on your Post-it note by your screen.
Right. So some more practical tips from this step. One is to find the papers. I would also add that it is a good idea as soon as somebody passes away, and Alicia might not even agree with me on this one, but as soon as somebody passes away and you know that their final affairs are going to need to be handled, call a lawyer and get a legal consultation on what this process is. And the reason I'm saying that is because once you do that, it actually gives you, one, the substantive information that you need. Legal consultations are usually pretty reasonably priced, right? You can get it done in an hour or so. And so even if you're paying for an hour of a lawyer's time, it's going to be, some hundreds of dollars as opposed to, many thousands of dollars. But as a practical matter, it equips you to say in response to those questions of, well, why are we doing this? Or, what is all of this for? You get to say, because the lawyer said this is how we had to do it. And a lot of times that can really help to calm and quiet some of those voices that are just intent on, people don't always intend to be jerks or to interfere or anything like that. A lot of times people really do feel like they have an obligation to be involved and to be up to speed with the details, and they go about it in a way that might be interfering or frustrating to the person who actually has to do the work, who actually is responsible for getting the work done. But also that legal consultation, you can bring them. Like, everybody can come to that meeting and hear the same information at the same time. And so whatever, however many couple few hundreds of dollars it'll cost you for that consultation, it's going to save you well more than that in peace of mind, because everybody hears the same thing at the same time. But anyway, that's a Jill specific tip. I don't know if Alicia would necessarily agree with that, but I would do it right away. I would pretty much do it as soon as I find out. I'm calling. We are getting on a lawyer's calendar, and all of you all are coming with me. So check your calendars. Who's available when? But
yeah, no, I would say that actually applies whether there's papers or not. Mm-hmm. And the reason that I kind of agree with that is it is always easier to know what to do and be pointed in the right direction in the front end than it is to have just been doing a bunch of stuff, or a bunch of different people are doing a bunch of stuff, and on the back end we got to figure it out, fix it, explain it,
account for it,
whatever.
Yeah.
So, and that's often, like, sometimes it's unfortunate, but that's when people land in our office is a whole bunch of messes happened, and this one's been doing this, that, and the other thing, and somebody else has been doing this, that, and the other thing, and they fell out, and so now it's the fight. And when it comes to these issues in probate, when we're dealing with these sorts of things, a thing to keep in mind that kind of helps you with understanding why, if we can have our best practices on the front and have everybody on the same page for why we're doing that, is that this is one of those places where nobody else is adding money into the pot.
Right.
So if we make a mistake and have all of this mess in there that we got to clean up and fix, we don't get to point to somebody else to have them pay to fix it or to pay for the expenses that the fix costs. It's coming out of that same pot of the money that is the estate. And so if you're one of the people that is entitled to something in the estate, all of this foolishness that happened is costing you money.
Yes.
Because all that's going to happen is the lawyers, and thank you, by the way, the lawyers are going to get paid, and all of the professionals, so the court's going to get paid, and some of the people that the court is going to require you to hire to do certain things are going to get paid. And when we talk about on that back end with that final distribution and the court setting who gets paid what when, all of those people get paid first before the family people. And so if all the fees have been drained in the cleanup, then what you might have gotten, which might have been many thousands of dollars might be 3.
Mm-hmm.
And so spending the few hundred, and it's really, when we talk about not going to be that expensive for a consultation, you're probably talking less than $500 to get an hour of time to just get a checklist, a blueprint to kind of run through. These are the preliminary questions to know what to do, what to get set up, what to gather, and then decide if you want to come back and have more support from that lawyer, or if you want somebody different or think you can handle it on your own.
Yeah.
But if you can spend less than $500 to do that analysis instead of having thousands of dollars on the back end because we didn't and are cleaning it up, like, I'm no investing wizard, but I feel like this is easy math.
Yeah. Yeah. No, 100%. And I'm really glad that that you made that point about the pot of assets or resources being fixed. It's all coming out of the same thing. It's all coming out of the same thing. So yeah. So tip number 1, I am dropping tips for stress-free probate. Okay, who are we kidding? A stress-reduced probate, right? Tip number 1, get a consultation with a probate lawyer right away, and invite your family or whomever is going to be involved in that process to that meeting so that everybody can get that information together at the same time.
A point on that tip is to also let the lawyer know ahead of time that this consultation is the family meeting where we want everybody to get the same information. Don't show up at the lawyer where they think they're consulting with one person who is going to do the job with all these other people, because then you're burning time figuring out, wait, who is all of y'all?
Yeah, no, that's true. And I would say that one of our very earliest episodes was about how to find and hire the right lawyer. And the second part of that conversation was about how to prepare for your meeting with the lawyer and pay for it. And so I would go back to that. I would encourage you to go back to that episode and actually get the full rundown on how to find a lawyer, how to and how to prepare for that meeting, because that preparation is not probate specific, and it applies to probate. So whether you are facing a probate situation or not, that information is going to be useful to you. Let's see. Tip number 2 is gather up the papers. Alicia already said that. Get the papers. And then I would say we touched on this, but I'm not sure if we said it explicitly for a tip number 3. That is, talk to your people. The deal is, you're gonna have to talk to them anyway. It is not. Listen, I'm coming in close to the camera. I'm coming in close. It is not possible to do this without people when there are people. Unless you're the only one, and the only reason why you're doing this probate is to cut off the time for creditors or bills or whatever, then you're going to have to talk to somebody. So just do it now. just do it now. And sort of going along with that, identify who those people are. The law in your state will tell you which people are entitled to notice and to be a part of the proceedings. It'll tell you whether it is everybody within 2 degrees of blood relationship or 1 degree of blood relationship, or whether step people are required, whatever, extended family, blended family, all of that. The law of your state will tell you exactly who is entitled to notice and to be a part. And you do not have to go sifting through big law books to figure that out. Just go to the court's website for your local court, and it'll tell you right there on the self-help page who you have to send notice to. Contact those people, get their addresses and that sort of stuff, so that you are, if that's all you do, frankly, that's fine. right? Because once you send them notice of the proceedings, they'll know what's going on in the probate, but you have to send them notice. And this is a constitutional due process issue. And so you can't skip it. You can't skip it. I do not know how many probate court proceedings I have seen held up for months on months on months on months on end because of these notice issues. And so, I mean, you can have a probate that would have been closed out in 6 months or, 6 or 8 months, done and dunked on at the first hearing, that ends up taking over the course of years because of issues like notice. So just talk to your people. And if you can't talk to them, find somebody who can. I'm sorry, go ahead, Alicia.
Yeah, no, I was just going to say, and make sure you look at the list for your jurisdiction and don't just make assumptions. Mm-hmm. Because even when there is a paper, sometimes the people that are entitled to notice is more than just who's listed on the paper. And so you need to know that so that you can get those notice boxes checked. Because like Jill said, if you show up and have everything else done, but you didn't have the notice done, your case is going nowhere except for a continuance to a new hearing date. And for some of those things, it'll cost you extra money. So an example of that is, for instance, in California, when we are starting the process of opening the estate and we have to publish it in the newspaper, the intent to administer this estate. If it's published in the wrong newspaper, or if there is some notice flaw that requires a republication, the newspaper doesn't give you you got it wrong on the first try break. They're charging you again. And that's a few $100s all by itself, just to publish in the newspaper. And so this is where that lawyer consultation that we already mentioned, and reading the stuff and getting all your cards on the table on the front end before you file paper one is beneficial, because what happens is you file that paper and the court is going to set a hearing date, and that hearing date is going to be out a certain amount of time. So let's say it's 6 weeks out, and there's some notice that needs to happen within that time, but you got to use that hearing date and back up from there, because you have to do it a certain number of days before the hearing date for it to be considered sufficient notice. So this is not, I can do it in the couple of days or weeks before the hearing. And so if you can have that information before you file the papers, then frankly, you can leave the courthouse with your hearing date and drop your notices in the mail to the people, rather than burning up that time that you have looking for the information to where you get to a place where you only get it 5 days before your hearing date, but now you don't have enough time to get it done in front of your hearing. So getting as much of this as you can before you ever file a paper is just going to set you up well. Absolutely. Not just for that first hearing, but for every single one that comes after that.
Yeah. And I don't think that I don't know if we've said this explicitly, but just in case we haven't, it is possible to have an entire probate proceeding done and dunked from start to finish at the first hearing. It is possible to only have to go to court once. And even if you have to go to court more than once, because the final distribution can't happen at that first hearing, you might only have to go twice. And that is the difference between getting a probate completed in 6 months versus getting it completed in a year plus. So that can really be a big deal. And part of it, I'm telling you, people think that a lot of this process is complicated. And what's really interesting to me in this work is that, yes, some parts of it are complicated, but the complicated parts are not usually what slow things down, right? We have professionals come in to handle the complicated parts, and they do what they do, right? But it is things like this, like notice, like finding the people. If I go to find a granddaughter or grandson's address and I realize that person is in the wind, maybe I'm not close to that person, maybe I'm the personal representative, but I'm not actually a family member. And so I don't know, I might not know everybody. I learned that I can't even find that person, but social media tells me that they're not dead. That means I'm going to have to find them. Well, that sure is important to know in terms of saving time and money ahead of time. I can get a private investigator, right, and do an air search if that's needed or whatever. I don't want to get us too far into the weeds, because you see that we can talk about this. We can talk. Well, y'all have been here before. I can talk. But I think it is important to spend some time giving this very, very first part of the process its due, discussion wise, because so much of the rest of how to do probate focuses on money and charts and spreadsheets and accountings and that sort of stuff. But honestly, you don't even get there until you get this basic, simple stuff right. And what appears to be a simple step may turn out to be a little bit more complicated in the execution, because it depends on other people.
Yeah. No, I think the key takeaway for me is that, and I tell people this all the time when they're like, do we need you? This is not a hard process. It is a very technical process.
Yeah.
And so sometimes that's where you want to have some support in, is because there are a lot of technical steps, but it is not hard to do. There are the complicated situations, they're out there, but they're more rare. Most of these are straightforward. It is just about checking the technical boxes down the line to make sure that you have that done. So shifting into our second stage of that probate, that inventory and appraisal part. So we've got the person, that's the point person appointed. Now your job is gather up 9 things so that we can figure out what we're dealing with. And so this is where as much of that information that you have on the front end also comes into play, because it's going to help this part of the process go smoother. And frankly, this is one of those things that once you filed the paper and you got your notices out and you're waiting for your hearing date, you can still be at work. And this is, if we have everybody on the same page and moving together, then they can all be helping so that everybody is making a collective effort to get through this process as quickly and efficiently as possible. Because this next stage of inventory and appraisal is going to involve things like we have to send notices to certain creditors and give them a certain amount of time to do, I think of it as the speak now or forever hold your peace moment. Because the court says, like, you got to send out the notice to all of the known creditors and the reasonably knowable creditors. And you're going to send them something that says, hey, this person died. We've opened the probate. Here's the case number. Here's the form. If you got a bill and you want it paid in this thing, this is your drop dead date. You better speak up, because after this, we're moving on with whatever got turned in. So it really is speak now or forever hold your peace.
Yeah. Judges say that death is the ultimate bankruptcy. So if you, whatever is in there, if you can be paid from it, if you're a creditor and you can be paid from it, okay. But there's competition. Right. There's competition. So, it'll behoove you to get in there soon. But yeah, sorry. Yeah. Go ahead.
No, that's important. And then we're also cataloging the assets in this one and getting official valuations on them, because, there's always the family has this property and one person thinks it's worth 12 cents and somebody else says it's worth millions. And so that is a place where if we've got the variance of 12 cents and millions, when it comes to the distributions, like the person who thought it was worth millions and finds out it was worth a quarter is going to be real upset and think that somebody did them dirty, because they had all their plans for their millionaire life that they were setting up and they only got a quarter.
Or the reverse, right? Or the reverse. Somebody is thinking that this thing is worth a quarter and it turns out it is worth, it's one of Basquiat's earliest works that's worth millions of dollars, and you were about to sell it at the estate sale for a quarter. So it's helpful.
Antiques Roadshow.
Right. Be on Antiques Roadshow. I love that show. But anyway, look, no tangents. Focus. I said I was going to be focused.
We are focusing.
Yes.
And so that is why we're going to do an official valuation as part of this inventory and appraisal. So the court, and this is one of those places where having your stuff together so we can get through this thing lickety split is helpful, because this is another place where, at least in California, somebody else is going to have that job for certain types of assets, and that person gets to be on the list of folks that get paid. And so they are going to put an official number on those assets that have to be valued by that person. So like main ones that we're dealing with here are going to be real estate interests. So we can actually set what is the number value for when we are moving forward for how we're distributing it.
Right. That's going to be true for just about all non-cash assets that are not like your typical sort of everyday household furnishings, right? So you might have to get a value for a car. You might have to, get some jewelry appraised. You might have to get some artwork appraised, or that sort of thing. And here is where I want to step back in, and I think this is probably just going to be my role for this conversation. I'm just kind of falling back into it, and that is to come through with the practical relationship sort of tip here. This is the place where knowing who the people are also really, really helps you as the personal representative, because remember, the personal representative's job is to make sure that it all happens. The buck stops with the personal representative, with the fiduciary, but they don't have to do every single task. So I'm going to offer a tip that a veteran bartender gave me. I was bartending in college, and they said, you know what, when you got people at the bar and they're just giving you this, just where's my, get something in their hand, get something in their mouth, because people can't fuss at you when they're drinking a beverage, right? Or when they're eating an appetizer. If there are lots of tongues wagging at you, give them something to do. Give them a job, right? This is a place where auntie or cousin who just has to be involved, right? And we all have them. Some of us are them, right? No judgment. That is me. I am some of us. Give me something to do so I can get off your nerves, right? The job might look like go over to grandmother's house and get the mail, check for all of her bills. Because the bills, Granny was old school. She was not doing online bill pay. Go and
alphabetize them.
Right. Get the bills. Get all of the bills and alphabetize them. And then tell me, make me a spreadsheet with the bills, with the contact address, and that. Bada boom, bada bing. All of a sudden, Jill is out of your hair and off of your nerves. And I feel like I am contributing. So I don't... You know what I'm saying? So I'm less likely to be a nuisance, right?
Yes.
So
this is very much that moment in the movies, like we have all seen it, when the baby is coming and the man is freaking out and is running around like Chicken Little, and they send him to go boil some water and gather some towels and blankets. Like, is that useful? Yes. Is it necessary? Kinda. But it also gave you something to focus on. So you can go over there being like looking at your little pot and watching your water boil with great intent. And it focuses that energy. This is really that.
Yeah. And it's one less thing that you have to do as personal representative, because you can hear already that there's quite a lot to do, and it's a bit much it can be a bit much for one person. So why not have some help? You have people who want to be involved, and it kind of, to borrow Alicia's term, it can also help to sort of create a speak now or forever hold your peace sort of moment with those wagging tongues, right? It can create a moment of, okay, well, if you got a lot to say about how this is done, why don't you get involved with how it is done? These are the tasks that need to be accomplished. Get in here. or otherwise, don't.
Somewhere.
Right? Like, so.
Exactly.
So, anyway, I'm sorry. Go ahead. You were talking about creditor claims, and there was an interesting example from recent history that you were going to share.
Yes, I'm glad you brought that up. So the recent example, so we're talking about this process of inventory and appraisal and creditors' claims and just this cataloging process. And something to know, particularly if somebody is reaching out to you about a probate that you might be involved in or entitled to notice on, sometimes this part of the process of those creditor claims and that speak now or forever hold your peace is the whole reason for the probate.
Mm-hmm.
Sometimes there is not a question about who the things are going to, and there's not a question about even the assets that are involved. But we want to have that start time so we get a finite stop time for how long somebody can present their creditor claims. And in order to get that, we are opening the probate to do that. So the recent example of it that came up is in the news last week. It was widely reported that the widow of Chadwick Boseman opened a probate case in California. Mm-hmm. And they said there are probably just under $1 million worth of assets that they believe to be a part of this estate. And he was married to her. There's no question about that. And there are no children involved. His parents survived him, but we know who those people are. So what that tells me as the lawyer is we already have designed exactly who the things are going to by way of the probate code. The reason that this probate exists is for that speak now or forever hold your peace moment. Because the truth of the matter is when we have a surviving spouse, there is a shorter process that we can do that's called just transfer to my spouse, basically.
In California.
In California.
Yeah.
Yeah. It's called a spousal property petition, but it is very much an example of we know that his widow would have been in position to just do that, but what that doesn't get you is this creditor protection. So by going through and paying the additional filing fee, which is a couple $100 extra, and going through the full process, what it allows for is opening that time window that I'm sending the notices out there and putting it out there. And so that's part of why you see it reported in the news even. Like that is helpful information to them. Number one, it's because it's a public process. So there would not have been an avoiding of that. But that's part of why it gets published in the newspaper, for instance. It's we put it out there for everybody that might need to know. We're starting this. This is the date where we're showing up. And so this is giving you notice. This is your end date. So if you're going to speak, this is your moment or we're moving on. So your practical tips for this one, in addition to your people and everything, are going to be gathering all of the financial information, as much of it as possible. So that's where you put the busybody auntie at work of gathering up the banking papers and getting those account numbers, looking at credit card bills or bank statements, whatever those things are, because that's going to give you your information for what assets we need to add on the list, who we need to give notice to as far as creditors, as well as identifying the information that's going to be in play here so that we can get that final distribution petition. Because, spoiler alert, all of the stuff that ends up on this list is getting you set up for the next stage of your process, which is that final distribution piece. And that's the step where now we've got all of the cards on the table. And now we're going to put together in a format for the court, the blueprint of these are all the things. We sent the notices at the end of the time frame. These are the people that step forward and say, hey, about my bill. So now that we have that list of people, as well as the people that are either the people identified in the papers that are getting things, or the people that the law has said are in line to get things, we've identified all of those people. So now court, this is our proposal for the bills and who gets paid and the priority of those payments and who gets the distributions. And this is also a place where your preparation and getting everybody on the same page is helpful, because you might be able to take advantage of an opportunity to negotiate with some of those creditors to get some of those bills reduced. But having all of your information and everybody on board on the front end, and everybody that you might need to sign off on some of these things if you want to take advantage of these opportunities, this is where that's useful for you, because then you get to put all of that in the court process. Because what the court is going to be looking for is, A, this is the list of everything in the plan for how we're going to do it. And you go to court for the court to bless that and say, yes, that looks like that's solid, go with it. And then coming back to say, it's done, let's close this thing out. That's what this part of the process is all about.
Yeah, this is, I think that, or at least my hope is that in hearing us talk about this, you're coming away with an understanding that, for lack of a better term, it just don't have to be all that, right? All of the hand wringing and consternation that comes from what we might believe about, or what we might have been told about, or what our past experiences of a probate or handling somebody's final affairs might have informed us about what this process is, that it just doesn't have to be all that. That it can be grief filled because we've lost somebody, maybe somebody who was even close to us or that we cared about a lot. It can be that, but the technical and administrative aspects of it don't have to be as wrenching as we might otherwise think that they are, or our past experiences might have been with it. Getting organized early and building some barriers, not barriers, but boundaries, right? And funnels. It at an early stage and in a transparent way can really, really help. How you start this thing really can influence in a positive way how you finish it. It does not have to be the experience of slogging and just sort of dragging people and process through with you to the finish line. It just doesn't have to be like that. And it also, getting organized like this early on also allows you to kind of see from a high level at the beginning what you want to delegate, and it allows you to make informed choices about what you can take on, which is huge, especially in the context of grieving, right? It's okay that you might not have capacity to, emotional capacity, spiritual capacity, even sort of physical time capacity to handle every single one of these tasks, right? You might not have that, and that's fine. But knowing ahead of time what needs to be done, getting some organization around it, identifying where the pitfalls and missing information might be, and who where the thorns, like where the people thorns might be, because when somebody passes away, that just kind of happens, and it's not because people are bad, it's because people are people. And so knowing that ahead of time can really, really, really help influence your experience of this process. It really doesn't have to be all bad. Sorry, I couldn't hear what you said. Sorry, Siri wanted to be a part of our conversation, so.
Yeah, Siri likes to butt in a lot. So I'm looking at my watch like I wasn't even talking.
So anyway, we're coming up on our hour together, on our lunch hour together, and I really hope that there's been some value here. I know that this has not been a legal sort of how to, this is what paper you get and what paper you file. conversation, and that's intentional for all the reasons that Alicia said at the very beginning. But I hope that, sort of getting below the line a little bit, and having sort of a practical nuts and bolts conversation has been useful. As always, drop us your questions, drop us your concerns, as we talk about what next week's conversation is going to be about and where you can find us. Please feel free to take that time to bring up any questions or concerns or thoughts that you might have, because we always want those. And before I turn it back over to Alicia to talk about next week, I just want to sort of recap those tips that we were talking about. First, what is probate? Probate is the court-run process for handling the final affairs of somebody who's died either with a will or without one. Right? That's what probate is. It has 3 main steps: opening the probate and getting the personal representative / fiduciary appointed, inventorying the estate assets, and also liabilities or obligations. I tend to think of this step with the title to part of Maya Angelou's memoir, that Gather Together in My Name, right? Gather up everything. And then, of course, there's the final distribution and closing out the estate. Tips for reducing your stress during probate: get a consultation with a probate lawyer right away. Invite everybody to that, and tell the lawyer that you're inviting everybody to that. Find the papers. Just find the papers. It is the start of everything. Even if you're just learning that there are no papers. Talk to your people. Unless you're the only survivor, it is not possible to go through this process without involving another human. So talk to your people. Do that early. Get up-to-date contact information for everyone who's going to be involved. And then, last but certainly not least, delegate. Give people jobs, especially the busybodies. Give them something to do.
Go boil the water.
Right, so go boil the water. Alicia, take us home, if you will, please.
Sure thing. So what's coming next is conservatorship and a practical approach for that. So this one was somebody's died and we have to go to court. Conservatorship is somebody is alive but needs some care support, and we may need to go to court. So we are going to do a practical approach there. We always give you a homework or something that you can do right now item. And for this one, it's think about your family. And if you all have a family tree, if you don't, then this might be a great thing to do, is to put together that family tree with the contact information and birth dates for all of the people in the relations. And something that someone in my family has done that I offered to you as a potential is they made a family birthday chart like that and used it as a Christmas gift. And so got crafty with it and sent it to everybody where they could hang it on their refrigerator with all of the family connections and birthdays. And so that will be a good way of having it set up for if this is needed for someone in the family. And so with that, you can find us here every Wednesday at 12:30 Pacific time on the YouTubes. You can also find us on Instagram. Our Instagram page is Dahlia Law Group. You can find us on the website at www.Dahlia Law Group, and our email is DLG, which stands for Dahlia Law Group, at DahliaLawGroup.com. And so in all of those places, we encourage you to reach out to us if you have questions, if you have comments, if you need some help, if you need to talk to a lawyer. Turns out we are, and we would love to talk to you.
All right. Thanks, you all. Have a wonderful rest of the week. If this information is or has been useful to you, please share it with someone else. If it has not been useful to you, please share that feedback with us so that we can course correct and adjust, because our whole purpose for being here is to be of service and to give information that is useful. Thanks, y'all. We're going to sign off.